The Supreme Court will be taking up a gun rights case.
Members of the Senate are focusing on gun rights.
Major Supreme Court ruling.
There is a difference between states deciding how they want to regulate any number of things versus stripping people of their rights to self-defense.
What's it take for an officer to determine there's an emergency and then enter into your home?
Constitutional protections of your home are absolute.
New York has introduced another bill that would require police to seize any guns in the home anytime they're called on a domestic without a warrant.
A gun confiscation law just went into effect in New York that fundamentally changes how police interact with firearms during domestic calls, and what makes this legislation unprecedented is one specific word: requires. Law enforcement is now mandated, not permitted, but required, to confiscate firearms during any domestic incident call, even if nobody is hurt, even if nobody is arrested, and even if the officer finds no evidence of actual danger. This isn't proposed legislation working through committees or waiting for implementation. This is active law, enforceable right now. On October 16th, Governor Kathy Hochul signed Assembly Bill A0544B, and it became effective immediately. What happened next should concern anyone who cares about due process, regardless of their position on gun rights, because the implications extend far beyond Second Amendment debates into fundamental questions about property rights, judicial oversight, and the power we grant to individual officers in moments of subjective judgment. Here's the scenario that legal experts are highlighting. Your neighbor hears raised voices, calls police about a possible domestic situation, and officers arrive to find you and your spouse having a heated discussion about finances. Under this law, those officers must take your firearms. They must take your carry permit. They walk out of your house with your property. No warrant was issued. No judge reviewed the situation. You weren't charged with anything, but your guns are gone, and getting them back requires navigating a process that most people will struggle to complete successfully. What makes this different from every previous gun law is the complete removal of judicial oversight at the point of seizure and the extended timeline for retrieval. Let's break down exactly what's happening, why it matters beyond gun rights debates, and what the evidence shows about how these laws actually get implemented. The original 2020 law that this new legislation expands allowed police to hold firearms for 48 hours before owners could retrieve them. This new law extends that seizure period to 120 hours, 5 full days. During those 5 days, you're sitting at home without any means of self-defense while potentially facing the very person or situation that triggered the police call. Think about the practical implications. The person who made the accusation, whether genuine, mistaken, or malicious, knows police just removed all firearms from your home. If that person had hostile intentions, they now have a 5-day window where they know you're defenseless. If there's a legitimate break-in or threat during those 5 days, you have no legal means to protect yourself or your family. But here's what makes this even more problematic. Getting your property back after those 5 days isn't automatic. You have to prove your innocence rather than the government proving your guilt. This inverts the traditional burden of proof that underpins American legal systems. You'll likely need to hire an attorney, take time off work, gather documentation, and potentially spend hundreds or thousands of dollars just to retrieve property that was taken without any criminal charges being filed. The average attorney cost in New York runs between $250 to $500 per hour, and this process typically requires multiple hours of legal work. Statistics show that 40% of Americans don't have $400 saved for emergency expenses, which means nearly half the population couldn't even afford to get their own property back. What happens to those people? Their firearms either remain in police custody indefinitely, get destroyed, or get auctioned off, effectively converting temporary seizure into permanent confiscation through economic barriers. Red flag laws, whatever your opinion of them, at least require a judge to review evidence and sign off on a seizure order. There's a hearing, presentation of evidence, and judicial determination before property is taken. This New York law eliminates that judicial oversight entirely at the point of seizure and puts all power in the hands of responding officers. A single police officer now has more authority over your Second Amendment rights and property rights than a judge sitting in a courtroom reviewing sworn testimony. This should concern everyone, regardless of where you stand on gun policy, because it establishes a precedent where constitutional rights can be suspended based on subjective officer judgment in the moment without any neutral arbiter reviewing the decision. Consider the statistics on domestic incident calls. Studies show that between 20 to 40% of domestic disturbance calls involve no actual violence or threat. They're raised voices, arguments about money or children, or situations that neighbors misinterpret from outside. That means millions of calls are made by people who misunderstood a situation, heard something out of context, or deliberately made a false report. In New York specifically, domestic incident reports increased by 15% in 2023, which translates to thousands more opportunities for this law to affect innocent gun owners. Your ex-partner who wants revenge, your neighbor who objects to guns on principle, or even a stranger walking by your house can trigger this entire process with a single phone call. Once that call is made and officers arrive, the law gives them no choice but to seize firearms regardless of what they actually find. Every firearm seizure under this law gets documented in law enforcement databases, and that documentation doesn't disappear just because you eventually got your property back. When you try to purchase another firearm, when you apply for a carry permit in another state, or when you undergo any background check for any purpose, that seizure shows up in the system. The FBI's National Instant Criminal Background Check System processed over 39 million checks in 2023, and each one pulls data from multiple law enforcement databases. Some states use these records as justification to deny permits or delay purchases, effectively punishing you for something that was done to you rather than by you. Employment background checks can also pull this information, especially for jobs requiring security clearances or positions in law enforcement or finance. Losing out on a career opportunity because a database shows a domestic incident seizure, regardless of actual circumstances, represents a permanent consequence for a temporary situation where you were never charged with any crime. The law provides no mechanism to expunge these records, no way to clear your name from the system, and no recourse for damage to your reputation or future opportunities. Insurance companies have also started using law enforcement records to determine homeowner policy rates, and a seizure record could increase premiums or result in denied coverage entirely. These cascading consequences mean a single police call, even a false one, can affect employment, insurance, future gun purchases, and legal proceedings for years or decades. California, New Jersey, Illinois, and Washington have all passed increasingly restrictive firearms regulations over the past 5 years, and they consistently look to each other for legislative models. When one state passes something novel and faces no successful federal challenge, other states treat it as permission to implement the same framework. New York's mandatory confiscation law is already being studied by legislators in at least 3 other states as a model for their own proposals. Gun control advocacy groups actively share legislative language between states, which is why you see nearly identical bills appear in multiple states within months of each other. Organizations like Giffords Law Center and Everytown for Gun Safety maintain databases of model legislation that state representatives can copy and introduce with minimal modification. Massachusetts introduced a bill in early 2024 containing similar mandatory seizure language, and it's currently in committee awaiting a vote. Connecticut legislators have discussed expanding their already strict seizure laws to match New York's approach. Even states that traditionally protected gun rights are seeing these proposals introduced, though they haven't gained traction yet. The pattern is consistent. One state pushes the boundary, waits to see if courts strike it down, and if nothing happens, 5 more states introduce the same framework within a year. Legal challenges take time, sometimes years, and during that entire period, the constitutionally questionable law remains in effect, affecting thousands of people. The Department of Justice has remained completely silent on New York's mandatory confiscation law despite having authority to investigate civil rights violations and file lawsuits against states that infringe on constitutional protections. When federal agencies fail to challenge obvious due process concerns at the state level, it sends a message to every other state that similar laws will face no federal resistance. The 10th Amendment gives states certain powers, but those powers don't include the ability to violate Bill of Rights protections. Federal supremacy means that when state law conflicts with constitutional rights, federal law and the Constitution should prevail. Yet here we are watching a state require warrantless seizures of property protected by the Second Amendment, using processes that arguably violate Fourth Amendment protections against unreasonable seizures, and the federal government does nothing. Supreme Court decisions like Bruin in 2022 made clear that the Second Amendment protects an individual right to keep and bear arms, and that states cannot impose restrictions without historical precedent. This mandatory confiscation law has no clear historical precedent. There's no point in American history where police could seize firearms based solely on an accusation without judicial oversight or due process. The law appears indefensible under current Supreme Court precedent, yet it remains in effect while legal challenges work through courts. What makes this particularly concerning from a civil liberties perspective, regardless of where you stand on gun policy specifically, is how it establishes a broader principle about property rights and due process. If the government can mandate warrantless seizure of one type of property based on subjective officer judgment during domestic calls, what prevents similar frameworks from expanding to other property or other situations? The precedent being established is that constitutional protections can be suspended based on accusations without judicial review, and property can be taken without due process if the government determines there's a potential safety concern. That's a dramatic expansion of government power that should concern anyone who values constitutional limits on state authority. The law also creates perverse incentives for malicious actors. If you know that a single phone call will result in police confiscating your neighbor's firearms for at least 5 days, and you have a grudge or want to harass them, the system provides a perfect tool for abuse with no consequences for false reporting. There are no provisions in the law for punishing false accusations, no mechanism for victims to recover damages from people who deliberately misuse the system, and no oversight to distinguish genuine concerns from malicious reports. This creates opportunities for weaponizing the law against innocent people, and there's substantial evidence from other jurisdictions with similar frameworks that this abuse occurs regularly. The broader question this raises is about the balance between legitimate safety concerns and constitutional protections. Nobody disputes that domestic violence is serious and that firearms in genuinely dangerous domestic situations create real risks. But the question is whether we address those risks through systems that include due process, judicial oversight, and burden of proof on the government, or whether we simply grant police unilateral authority to seize property based on subjective judgment. New York has chosen the latter approach, and the consequences will unfold over the coming months and years as the law gets applied to thousands of situations. What remains to be seen is whether courts will uphold this framework, whether other states will adopt it, and whether the American public will accept this dramatic expansion of government seizure authority as a reasonable response to legitimate safety concerns, or recognize it as an unconstitutional overreach that sets dangerous precedents for property rights and due process far beyond the gun rights context.